Sharif Medawar. I'm really excited about the call tonight. We're going to spend some time together. As you know, I am not an attorney. I'm not a CPA. I am a hedge fund manager. I'm an expert real estate investor. I have a training company, cmrei.com, and I'm also an author, as you know. And I have the book that was rolled out last year in 2015, Blue Ocean Opportunities in Commercial Real Estate. This was a bestseller on Amazon, and it's been having a lot of good feedback on many sites and many magazines. Also, we rolled out this year Successonomics with Steve Forbes. This book also became a bestseller, actually, first quarter this year. I'm not the only one with Steve Forbes in that book. They selected 50 or so wealth advisors. So it's really exciting for me to spend time with you to talk about how to protect your money, to protect your assets, and the equity you've worked so hard for. When you think about it, financial peace of mind is based on your assets producing income for you, and that earning power is what you have to protect. So if you think about wealth as three things, getting assets that produce reliable and growing income as step one, step two, minimizing the taxes, and step three, protecting your assets, you're going to find out that people that have built it and worked so hard for it can very easily lose it all. So this makes it very important for us. Now, many of you know I have a lot of commercial properties. I own practically streets in Old San Juan, Puerto Rico. I have a lot of properties in San Francisco, California, where the inventory is very expensive. In Puerto Rico, this street here is called Cristo Street. I practically own this one here, 211 Cristo, 209 Cristo, 207 Cristo, 205 Cristo. I mean, I own practically the whole street on both sides, over $50 million of commercial real estate right next to where the cruise ships arrive. So how do I protect myself? That's what I want to talk about. That's what I want you to understand because I learned it from the best in the business. Asset protection. We created the website KMAGB, Kiss My Assets Goodbye, the ultimate asset protection structure. It took me a long time, several years, talking to the best judges, best attorneys, litigation attorneys to understand this. And the ultimate goal was to create something that you can set up easily, you can use without complication, you can modify without a lot of expenses, and you can unwind at any time you want. This powerful structure helps you for lawsuits, prenuptial agreements, postnuptial agreements, real estate challenges, bankruptcies. You will see. You know, in today's world, anyone that wants to sue you can go to a good attorney that will take a case, a clever attorney that will actually go on some websites like whocanisue.com. They can go to Skip Tracers, these websites that actually you can plug in the name of a person or some information about them, and they can tell this plaintiff attorney all what you have. They can actually find any dollar you have, any equity in a building or in a business. Where is the risk coming from? If you think about it, car accidents, partnership disputes, employee actions if you're in a business that you own. If you are working on some great product, some competitors' lawsuits, they say you copied them or you stole something from them. You can have guests in your own home slipping, falling, and they can sue you. Divorces, 50% chance of divorce, it's crazy. Bankruptcy, your business can fall apart. How do you protect yourself from a landlord? How about if you're the landlord, how do you protect yourself from the tenant? How about you live somewhere? How do you protect yourself from neighbor lawsuits? These are big deals in the United States. If you're flipping homes, contractors and other worker disputes, if you're flipping homes, listen carefully. This is very important. If you're in real estate and you have leases and tenants, contract challenges. If you talk too much slander and libel, maybe somebody say you said something bad about them. What if you love pets and your pet runs out and does something, bites somebody or something, pet attacks? I can go on and on. I think you realize that you got to protect yourself, and lawsuits are all around us. Now, when you ask people or you go to attorneys, how do I protect myself? You get confused. You get some attorneys that tell you transfer assets in separate LLCs. Well, wait a minute. When you transfer an asset, okay, it's in your name, you have a loan, and you go and you want to transfer that asset. Have you read your loan documents? It says there is something called due on sale clause. So you have to now tell the bank that this is a transfer from you to your own entity. And it gets harder if there are investment properties. For your own home is one thing, investment properties even getting harder. How about when you transfer the property? Can't you get a bill for transfer tax? In California, you pay transfer tax, for instance. How about anywhere in the country when you get the tax assessor's office saying, hey, there was a transfer of ownership here, and we're going to revalue the property, and now you have a bigger tax bill. You see? And even if you separate your assets, like you put, let's say you have 4 or 5 properties and you put them in separate LLCs, do you realize that your equity in each property is still at risk? If you have a loan for, let's say, $200,000, and you have $200,000 equity, and you just put the property in LLC, guess what? You still have the $200,000 equity in it. They're going to go after that LLC. They're going to go after that structure. And you know what? Yes, you have isolated that LLC from the other stuff that you own, but you still can lose the money that you have, the equity you have there. How about using land trusts? Well, land trusts don't really help. In court cases, you can look it up online. Many judges say, we want to know who the beneficiary are. The beneficiaries have to be disclosed to the judge if they ask for it. Look at court cases. Anonymous Nevada Corporation. The judges previously have said, we want to know who the shareholders are, or we're going to take this thing. Offshore trust, you don't want to go offshore. You lose control. You don't know what's going on. You raise the flag for the IRS, and you're totally at the mercy of another country with another system. You stay under U.S. flag. You stay under the actual systems of the United States. Now, a lot of people say, do I just get enough insurance? Should I get more insurance? Well, we're going to talk about insurance. You should get adequate insurance, and then you should understand the ultimate asset protection structure, because we can get you set up in 72 hours from now, and for the rest of your life, your assets will be protected. Now, how does it work? Simple 6 steps. You should not show any equity in your asset. See, listen carefully. You don't need to transfer any asset out of your name or out of any entity right now. If you have it in your name, fine. If you have it in LLC, fine. The key thing is not holding the asset. It's what equity you have. So number 1, figure out how much equity you have in all your assets. Number 2, that includes your businesses. Number 2, we're going to set up for you one limited liability company in Wyoming. Wyoming is the state that created limited liability companies in the 70s. We have a very special business operating agreement that has over a dozen reasons why this Wyoming LLC exists. Now, if you have no cash to capitalize it, which is the whole idea here, we will use the equity you have in your assets and pledge it to capitalize the LLC. Now, this is all spelled out in the operating agreement. Now, number 4, we draft promissory notes. In other words, instead of saying, I have an LLC now and I'm going to put $100,000 in it, we're going to say, I have an LLC and I promise to put money in it. So that promise is a promissory note that we draft for you for each asset based on the legal requirements of each county and state. If you have a property in California, property in Wisconsin, property in Texas, and property in Florida, we draft the promissory notes according to each state requirements. We then get a lien recorded against each asset to show that it is encumbered, slightly higher than its value. So now you have a first lien to the bank and a second lien to the Wyoming LLC. These get recorded, and guess what? If you have a business, we'll also record a UCC-1 lien. This is a commercial lien that's recorded to protect you. It strips the equity of your inventory, the equipment, receivables, etc. 6 simple steps. Set up the Wyoming, we capitalize it with promissory notes, we record them for you, and now anyone looking at what you have will see that it's nothing to go after. If God forbid you have an accident, an attorney is going to look at it, is going to say, yes, this is an accident, I got to go after this person, it's legit. They're going to look at you, they're going to pull out the county records, they're going to say this person owes more than they own. They're upside down. And if someone sues you, it will be at a great expense, because they have to actually get a subpoena in court to go in Wyoming trying to find out who owns it, because there is Privacy Act. It's going to cost them a lot of money. The process will take too long. And even if they win and they're awarded a judgment with monetary compensation, not only do they not collect anything because there's nothing to collect, there are too many liens, the assets are over-encumbered, but they end up with a tax bill for what's called phantom income. So they get an award of a judgment of some sort, they don't collect anything, and at the end of the year, the IRS sends them a bill. Number 4, you would have peace of mind because Wyoming has a Charging Order Protection Act. So no one can go after whatever you have in the Wyoming LLC. Even if you put some cash in it, you put a trading account, you have a CD, and all that stuff, you put it in there, guess what? Nobody can touch it. You don't need to transfer any assets out of your name. It doesn't matter. You have your business in an S corporation, we strip the equity from it. You have your home in your name, we strip the equity from it. You have an investment property in an LLC, we'll strip the equity from it. All will go to one Wyoming LLC. No complicated paperwork. It's very simple to maintain. Now, I'm really excited and privileged. Tonight, I have with me John Lawson. John was a former judge in the state of Texas for 10 years sitting on the bench. He has over 24 years experience in law. He's been an attorney forever. He is currently an insurance defense attorney with fantastic experience, and I met him in person. We got to spend a lot of time together. So, John, are you on?
Yes, I'm here.
Hi, it's good to have you. John, can you hear me okay?
Yes, can you hear me?
Oh, yes, no problem. I think you were muted. So, John, could you give us your view with your background on the law, and I know you deal with a lot of plaintiff attorneys being in the insurance side, and tell me what you think of the equity stripping and the structure that we have created here.
Well, the good thing, I guess, about your asset protection is what a good defense attorney always likes to see is if you're representing somebody, you really want them to be broke, because a plaintiff's attorney is not going to go after someone that doesn't have any money or doesn't have any assets. The good thing about your asset protection program is it strips the equity out of all the assets, so when a plaintiff's attorney or someone looks at it, there's nothing there for anyone to get. And that makes it a great tool. And a plaintiff's attorney because a lot of times plaintiff's attorney take their cases on a contingency basis, and so if they don't get money out of the suit, they don't get paid. Now, there are exceptions to that when you start talking breach of contracts and things like that, but still, an attorney is not going to waste his time going after somebody that doesn't have anything or doesn't appear to have anything.
Very good. John, if you don't mind, can you give all the audience and listeners here a little bit on your background? I think it's going to add so much value for them to understand what you deal with, etc.
Yeah, I was what I call a small-town judge for a municipality for, I guess it was about 10 years, and, saw some small claim type stuff, but nothing just horrendous. But it's still, you see enough there to see how people will go after whatever they can get if they can get it. I'm also currently an insurance defense attorney. I've been doing that for, I guess, out of my practice, probably about 14 years. I've also used to be a bankruptcy attorney. I had a practice that did a lot of bankruptcy, and I guess it's I've done a little bit of everything. I know the exemptions, at least in the state of Texas, very well to know what creditors can get and what they can't get, and how they can supposedly get it and how they can't. I don't use that as much in my insurance defense, but when I was in bankruptcy practice, I used it all the time.
Oh, that's fantastic. Well, I would love to talk to you about three things: about insurance, if it's ever enough, about bankruptcy with this type of structure, and about homestead. Let's start with insurance.
Well,
in your opinion, if somebody has insurance, is that enough, or do they still need to strip the equity?
Well, with insurance, you never know whether it's enough, because most people, and at least that I come across, usually have, with their homeowner protection, it's usually $300,000 policy. With their cars, you have anywhere from what we call a 30-60 policy, which is $30,000 per person, $60,000 per occurrence. And usually they have a $30,000 property damage. Well, some of the cars nowadays are worth $40,000 and $50,000, so you can see that's not enough to cover you. A lot of times people tell you don't get underinsured or uninsured motorist coverage, because in Texas you're required to have that liability coverage. Well, just because you're required to have it doesn't mean everybody has it. So in my mind, you can never have enough insurance, because even if you have your $300,000 policy protecting your home, then you go out and get an umbrella policy. And I think most people would know an umbrella policy is basically over and above the $300,000, and usually you can get $1 million, $2 million, whatever coverage you want, and it's fairly cheap when you look at it. So, I mean, can you have enough insurance if somebody comes and a dog, a pit bull, chews somebody's leg off, a couple of arms and things like that? Is $1 million enough? Who knows? If he happened to be a concert pianist, probably not, because he loses his job and his way to earn a living and things like that. So you have to look at everything that that happens. But there are times, believe it or not, when you can have too much insurance, because I see a lot of cases that I do where someone will have $1 million umbrella policy and a $300,000 policy on their home, which is a total of $1,300,000. Somebody comes in, and had they had just the $300,000 policy, most of the plaintiff's attorneys would come in and say, we'll take the policy limits, boom, it's sold. Even though they may have had $400,000 or $500,000 in damages, they'll settle for whatever they can get, which would be the $300,000 policy. In that case, if you've got the umbrella policy, a lot of times they say, oh, well, now we've got $1.3 million. We're going to keep on going until we get it all. So, believe it or not, sometimes you can have too much, but I would rather err on the side of caution than having too little. So, I mean,
so really, then, when it comes to insurance, having the right amount plus an umbrella insurance, and then on top of all that, stripping the equity is the ultimate structure, don't you think?
Yes, I mean, it would be, because then with the equity that's taken out of your assets, all they have to go after is the insurance money, and that's that's what insurance is for.
Okay, may I ask you? You have dealt 13 years with insurance cases. Don't you agree with me that insurance? I hate to put it this way, but sometimes they try to deny the claim. Sometimes they don't want to. They claim maybe contributory negligence. Maybe it wasn't exactly based on the contractual agreement in the policy, so they try to maybe deny paying the full amount. What's your view on that?
Yeah, I mean, occasionally that happens, and it depends too. If you've got somebody that has made multiple claims, and then all of a sudden somebody else, call it family member, sometimes somebody close to them, friend, comes onto their property, gets injured, and it looks suspicious. Sometimes the insurance carrier will do an investigation, and sometimes, they find that it was a fraudulent claim. Sometimes they don't. But, there are times when the insurance policy may not apply because you've done something wrong. If you come in and say that this is going to be a single-family household and you've got, 4 families staying in that home, and somebody gets injured in one of the families, they may look at some part of the policy and try to exclude that coverage and not pay. I mean, it happens.
Got it. So having insurance and complying with that is important, but having the stripping of the equity gives you the extra layer in case any of the claims get denied or the insurance company finds ways to get around it. Well, sure. So let me ask you about bankruptcy. If somebody set up this equity stripping and had no intention to do anything bad, but 3 years later, they've been paying as agreed on the promissory note, they make one payment a year to the promissory note, so they strip the equity of their properties, etc., but then they fall on hard times in their business and they want to file bankruptcy, isn't there a good chance, in your opinion, isn't there a good chance that a judge could look at this and say, okay, if they claim everything on the statements, they have to claim all assets, all liabilities, and they could see that this this structure has been in place for 2-3 years, and it could actually be accepted by the bankruptcy court? Is there a good chance?
Yes, it very well could, because, and it's going to sound, I guess, bad in some respects, but if you've stripped all the equity and the assets in there have no equity, then technically when you look at the LLC itself, is it going to be worth anything? And it may be that if you use under the bankruptcy code federal exemptions, the LLC may have a value that you could actually exempt under the federal exemption under what they call the wild card exemption. So I mean, there's but the thing, yeah, it's just you have federal exemptions and you have state exemptions. Some people, and you have a choice as to which you want to use in what I call a personal bankruptcy, because I only did Chapter 7s and Chapter 13 consumer bankruptcies. I didn't do the big Chapter 11 American Airlines type bankruptcies. Mm-hmm. But yes, when you have the lack of equity in there, it's just like on a car. You're entitled to so many cars to keep in the bankruptcy, and if you don't have equity in that car, it doesn't really count against your amount that you can exempt because there's nothing there. So
very good point. Very good point. Wow, that's amazing. That's another added advantage I never actually thought of for the equity stripping and the way we handle the asset protection. So let's talk a little bit about homestead, because Texas is phenomenal when it comes to homestead, and Florida, and we have so many students and so many states that have homestead. Could you give me your 2 cents worth, and is that like all people need when it comes to their home? What do you think?
Well, no, because, and I can only speak to Texas because that's the only law that I know. But in Texas, your homestead provisions, like you've already said, they are excellent. The homestead is protected 100% from creditors, but that doesn't mean that it's totally protected, because all the homestead law in the state of Texas does is if you get a judgment against you for $1 million, it prevents the creditor from being able to come in, go to the court, and force you to sell your house. So you could have a $1 million home that is completely paid off, and the creditor cannot force you to sell that house to pay his debt under the Texas homestead law. But where there's, I guess, kind of a false sense of security is the creditor can still file his judgment in the county where he got it, or the county where you have that particular homestead. He can keep filing the judgment or refiling it, because in Texas you're required to refile the judgment every 10 years. In that same time period, it's steadily gaining interest on that judgment. So 10, 15, 20 years down the road, if that creditor has continued to file that judgment and both of the debtor or the owners of the home pass away, there is no homestead protection at that point, because it's no longer a homestead. It's now part of the estate. So I mean, that's kind of a fallacy. So at that point, the creditor could potentially come in and try to get it at that point. The other factor with the homestead is that, let's say that, okay, it's protected, so I'm going to take the home and sell it 5 years after he gets a judgment for $1 million. You try to go sell that house, you can sell it under Texas law. You have 6 months to either reinvest it in another homestead, or it basically becomes cash in the bank. If it becomes cash in the bank, that's not protected, and they could come in and get it. So, I mean, so there are some fallacies. Now, I wish I could tell people that are listening from the different states that they're in what those are, but I don't know them, unfortunately.
Yes. And what Texas has, I mean, this is 100% homestead, And yet, as you explained so clearly, it's really a fallacy because whoever wins the lawsuit now, realize, everyone listening, that that plaintiff that became now a creditor is going to have a tax bill. So he's now mad as hell. He's going to wait and file that lien against the property, the homestead, and he's going to wait for the person to either sell the property or to die and not follow the rules of, when they sell the 6 months, etc., so they can get their hands on that home and collect on the judgment, because the judgment is also collecting interest, and they're paying interest on phantom income. So they're paying taxes on phantom income on that interest. So they're getting madder and madder every year. However, if they actually got the judgment and found out there is actually no equity in that home, and it is a homestead, but there's still no equity, they're going to be very discouraged from the get-go. They may not even go for the lawsuit, number one. Number two, if they win, they may not just let it drop and move forward. They may try to settle for a discount or something because they don't want to deal with all the hassle. There is nothing for them to go after. Am I right, John?
Yeah, and some of my hardest cases to settle were in cases where the plaintiff's attorneys had done their job, and they went out, and some of them will actually spend $1,500 to $2,000 to run an asset check, and companies find all these different things. Because I've had people that have had 5 and 6 paid-for rental homes that they have, and those are the hardest ones to settle, because now if each one of those rental homes is worth $50,000, well, they've got $250,000 worth of assets out there that if they get a judgment, they can attach them and they can force the sale.
Yes, so whatever equity is out there, they're going to go after. Very good point. So we covered insurance, that we still need the asset protection structure we have. Bankruptcy is going to be wonderful. Get it set up as early as possible, because 2 years once it's in, it's powerful. Homestead, you still need the equity stripping, the structure we have. And by the way, for those that, let's say, you're in Texas and you have a home free and clear, and you're afraid to get sued even though you have the homestead, because now you understand the risk. So we will strip your equity, and what we do is we make the Wyoming LLC owned by your living trust. So when you die, it passes on to your living trust and to your loved ones, and the entire process still looks like the property is over encumbered. So you are protected from the minute you set up to 30 years, and then we renew notes, etc. So, John, is there any time where it's not good to set up this structure? Like, let's say a lawsuit started already. That would be too late to structure this asset protection?
And that's one thing I was going to say. It's once the lawsuit is filed, it's too late. If you wait till the lawsuit is filed, anything you do once the judgment is rendered, from the time of the filing all the way until the judgment is rendered by the court, the judge can do I call it a look back, and he can see everything that you did with assets. And if he sees you setting up corporations, setting up LLCs, sending money to either overseas or sending it to relatives or anything like that, they can trace that money, and if they trace it and find it, it's going to come back into the estate and be used to pay. So, yeah, if you wait until the lawsuit is filed, you're too late. All the bets are off at that point.
Exactly. That's why I keep saying we've done a couple of these calls, and I tell everybody, and we've gotten very good responses. I say anyone that's really, truly serious about asset protection, don't wait. Set it up. Get us to structure it for you. We will handle it. You will only maintain one Wyoming LLC every year, and it's very simple structure. You will have the certificate of ownership. If you want to, borrow against the property, if you want to sell the property, you're in control of the lien that is actually owed to your Wyoming LLC. All right, Ashley, do we have any questions that we can take right now?
We do. Yes. Let's start with Alicia and Carolyn are asking for you guys to compare a land trust to this structure.
Okay. Well, simply a land trust, all it does is it just says, you have the grantor, or the trustor, the trustee, and the beneficiary. Well, the beneficiary doesn't get recorded anywhere, so nobody knows who is going to be the beneficiary. So we just have the trustor or the grantor and who the trustee is. So we record the trustee, which could be an attorney, could be a family member, etc. But the point is, when you put a property in a land trust, it doesn't mean anything, because what happens is when there is a lawsuit, a judge in court, and you can look it up online, says, I want to know who the beneficiaries are. And then they have to respond and say that to the judge. Versus this structure where even if you say, yes, I am the owner of the LLC, since you set it up, like John Lawson said, before the lawsuit was occurred, and you had set up this, and you have the operating agreement, and you make one payment a year to the actual LLC that has a lien against your property, no matter what happens, nobody can go after your property or your equity, and it's just completely airtight. John, anything you want to add to that?
No, I mean that's pretty much right. I mean, I have, in my experience, I have found land trusts are not. They're not really a vehicle to protect you from a lawsuit. They're a vehicle, in my mind, more to protect you from what I call the Grim Reaper creditor, the estate tax and estate problems later down the road. That's my understanding of what land trusts are better for but they're not really to protect your assets if used by themselves, so to speak.
Yes, sir. Okay, Ashley?
All right, next question coming out of D.C. If I have investment properties in a few states and in a few different names and LLCs, can I set up one operating agreement?
Yes, that's what we do. We set up one Wyoming LLC with one operating agreement explaining why this Wyoming LLC exists. We put over 13 reasons why it exists, and then that Wyoming LLC, we issued a promissory note against each asset, no matter what the assets are and no matter what they are titled as. They could be titled under an LLC in Texas, under a C corporation in Florida, or under a personal name in New York. And what we do, we still put the promissory notes and the liens according to each asset in each state, and everything is owed back to the Wyoming LLC with one operating agreement. That is correct.
And I would say that the good thing about your asset protection is, no offense, Sharif, you've already spent the money to perfect it with the attorneys and all that, because the operating agreement that's the guts of the whole LLC. And if it's not set up properly, it opens it up to be attacked by, the smart attorneys, because no LLC is ever going to be perfect, because at some point in time, there's going to be some Harvard lawyer that's going to figure out a way to come at it in a different angle that nobody's thought of. But that just had never happened yet.
Yeah, Wyoming has been pretty good. Thank you for that. Okay, Ashley?
Next question. Can you add assets as you acquire them and place them under this Wyoming LLC?
Yes, actually, this is very simple. We do the structure for $4,995 that involves the operating agreement, it involves the promissory note, the lien, the filing in Wyoming, all that stuff. And what happens is, as you acquire more properties, we just add liens at $695. That's it. We do a new promissory note with a new lien and send it to you. You notarize it, send it to the county to record it. This way, as you acquire new properties, you're stripping the equity and you're protected. And I will add to that if you are flipping property, let's say you bought a property for $200,000 and you're going to fix it for $100,000 and you're going to flip the property for $500,000. Well, guess what? When you buy it for $200,000, just call our office. For $695, we're going to get a promissory note and a lien, and we're going to actually protect you for the $500,000, which is going to happen when you fix the property. Maybe it's going to take you 6 months to 8 months. so you don't have issues with the neighbors trying to sue you, contractors trying to come after you, or whatever, God forbid, happens. Of course, you have insurance, but we're talking about protecting your assets, so when you turn around and you do the job and you do your business, nobody can come and mess with you and do what we call legal extortion, trying to threaten you so you can settle or whatever. Very good. Yeah.
Very good. Next question. If I have a California LLC, I still have to pay the state fees. How can the California LLC be protected by the Wyoming LLC?
Very good point. The California LLC is not going to be protected by the Wyoming LLC. What the California LLC is going to do, let's say this person has a business in California and they have it structured under an LLC. What we're going to do is we're going to have that California LLC equity, whatever is equity under that LLC for business, is going to be stripped to the Wyoming LLC. The Wyoming LLC just sits in Wyoming. It's just owed money. It encumbers the assets. So what we will do is we'll create a promissory note from the California LLC to owe money to the actual Wyoming LLC. And there is what's called legal substance. There is economic reason, which is what? It is to capitalize the entity. It's not a friendly lien. It's not a bogus lien. We are capitalizing an entity. We're in compliance with the operating agreement, like John Lawson said. And what we do is we just strip the equity of the California entity.
I can't get through.
Thank you.
Okay, next question. If I have a judgment against me for a previous issue and have not finalized the payments out, but I'm about to purchase another estate, can I set this up to protect that future purchase?
What do you think, John? I think for the future one, it's not an issue, right?
See, are we talking Texas or another state?
Hey, that person is in California, right?
Yes.
And see, I'll be honest on that one. In California, I would be afraid to speculate on that. In Texas, if you set up the new LLC, and this is where the problem would come in, is if you put assets that you currently have into that new LLC, I think the judge could do a look back and possibly have a problem with that, because anytime that lawsuit starts before you get anything set up, the judge is going to have the ability to look back at pretty much every financial thing you've done if they get that judgment. And so even though you start that new LLC, if you go purchase a property with money that you had hanging around at the time of the lawsuit was filed, and you use that money to purchase the property, the judge will follow it through, and he may very well rule, no, you used money that should have been used to pay this judgment, and he may try to undo it. Now,
very good point. I venture to say California will be the same. So this person should just settle the lawsuit or attempt to settle it. This way we can set him up the right way, and then from this point forward, he will never have to worry about lawsuits and issues like this in the future.
Very good. Next question. I have worked with many attorneys in the past who have been very slow. If I structure this and I am a flipper of single-family properties every 30 to 60 days, will the structure cover that property because I flip fast?
Yes, we can get it done within 4 days from the day they say I want it. So I could be as fast as you want me to be, and we can get it done. Yeah.
Very good. And for who asked that question, if you want to ask a follow-up question, go right ahead and ask me on the panel, and I'll get it over to Sharif. Next question. When a judge sees the liens, are they suspicious?
When the judges sees the liens, are they suspicious? Well, they see liens all the time because liens are the most common thing in the U.S. for any property. But John, you can answer that. What do you think?
Well, I mean, it's one of those things. You have judges that I guess are suspicious in nature, and you have others that look at it and go, lean, lean, lean. This guy's up to his ears in debt. It's not worth looking at. So, I mean, That's a hard question to answer because some of that depends on the discretion of the judge. Some of it depends on the plaintiff's attorney and how good a job they do. Like if they follow it back and they go, okay, here's the Wyoming LLC, and they try to find out that and they get a court, if they go through all the time and effort to investigate it and everything, but most of them are not because they only have in my mind, what I call a small window of opportunity to decide, am I going to take this case or am I not going to take this case? Am I going to be able to make money on it? And so, it depends on the discretion of the judge when he looks at it. Most of them, I think,
yes,
you look at the court system and how backed up it is, most of them are trying to get rid of the cases as quick as they can.
Yes, good point, John. I think the person is asking, would the judge get suspicious? Let me clarify something. Guys, we're not doing anything illegal. We're not trying to pull one up on the court system. This is why I repeat, it has economic substance. If the judge says, okay, who is this LLC owned by? Who is the owner? I can send right there and say, I am the owner of the LLC. It's a flow-through entity to me. Here is the operating agreement. The judge now is going to look for the operating agreement. And why are these liens created? Oh, the liens are created to capitalize the entity. Then the judge is going to say, when did you set it up? Oh, before the lawsuit. Okay, it says that you have a promissory note. Are you really making the payment according to the promissory note? Yes, Your Honor, here I am making the payment. This is not like the judge is going to get suspicious. Oh, my God, he got me. The judge can get suspicious all day long, and we're going to disclose, full disclosure. Am I right, Rob?
Yes, I mean, that's totally right. It's just, as I say, at that point, though, if he is looking at it, it just becomes his discretion as to what he does. And unfortunately, believe me, you'll never be able to guess what a judge will do. But I still think because you're up front with everything, everything's above board, you're going to be okay.
And I guess the key, like you said, is when do we set it up? Have we set it up to fraudulently convey assets, or have we set it up with proper economic reasons?
The biggest thing is be proactive, not reactive. If you're reactive, you're losing.
Meaning to set it up before a lawsuit,
yes.
Not after,
yes,
right?
To set it up.
Yes, very good.
Very good. Okay, next question. Please clarify phantom income.
Phantom income is, okay, go ahead, John.
Well, I can give a decent example on that because when I was a bankruptcy attorney and a mortgage company would come and foreclose on a house, and let's just say that they owed $200,000 for that house, they foreclosed on it, the mortgage company would send the tax documents to the IRS on that debtor and would turn in $200,000 of income for that house that they no longer owned, that they weren't living in and all that. That's phantom income because the IRS looks at it was they were given $200,000 to buy that house. They no longer have the house, so that's income that they have to pay taxes on. And it's the same thing with the creditor. The creditor, or in this case, the judgment, the person that gets the judgment, he goes out, gets a $100,000 judgment against a person that has the assets set up like Sharif is talking about. You have that $100,000 judgment. Well, if he doesn't actually collect it, it doesn't matter. The IRS sees he got a $100,000 judgment. That's money he's going to have to pay taxes on, whether he gets it or not. And that's where the phantom income comes in.
Excellent. Thank you. Very clear explanation. I have nothing to add.
All right, next question. Why are you utilizing a Wyoming LLC over a Nevada LLC?
Wyoming is actually, this could lead me to the next one. Wyoming has the charging order protection. John, you want to talk a bit about charging orders? Maybe you would clarify it better.
Well, I mean, as far as a charging order, when you're talking about an LLC, if the creditor, and I keep saying creditor, if the person that has the judgment, let's say that, okay, here's this Wyoming LLC, and for some reason they believe they can go after the Wyoming LLC. So they go after the Wyoming LLC, file the proper paperwork, they get a judgment against that Wyoming LLC for, just say, $100,000. Well, when they get that judgment for the against the Wyoming LLC, the charging order says, and what they're trying to do is they're trying to go, okay, the person that owns this LLC is now going to have to pay us money. Again, we go back to the operating agreement. In the operating agreement, it's going to say something to the effect of the manager of the LLC can determine when a payment is made out of the LLC. In other words, when the income is dispersed from the LLC. Well, in the charging order, if the manager of the LLC decides, well, for this year, even though we've got $300,000 in the bank, we're not going to disperse any income to any of the members. Well, if the person that got the judgment comes in and says, well, hey, I'm taking the place of member B because I got this judgment against member B, so now I'm taking his place in this LLC. Well, he can't force the LLC to disperse the funds to him, but he gets the tax for the $100,000. He has to pay the taxes on it, whether it's dispersed or not, because that's part of his income. And I may have gotten off point there, but
yes, this is very good. Now, also, Nevada C corporations have charging order protections as well. However, the LLCs are not as powerful in Nevada as they are in Wyoming. As a matter of fact, it was practically 15 years later that LLCs were set up in Nevada, according to some websites I've looked at, because Wyoming structured LLCs in the 70s, and it was way later that Nevada did for LLCs. Now, so let's go back to what other entities have these charging orders. It's C corporations in Nevada. The problem is C corporations require a lot of paperwork and documents to be maintained yearly. People can pierce through C corporations very easily, etc. A lot of attorneys are familiar with Nevada structures, but when it comes to a Wyoming LLC, not only do we have a Privacy Act in Wyoming where it doesn't show who the owners are or the managers, you have to get a subpoena and go to the actual resident agent to get the disclosure. So it's an extra barrier. It's not a big deal. I mean, I don't mind telling anybody I have my Wyoming LLC. The thing, it's an extra barrier to anybody trying to sue me, number one. Number two, the filing fees are $200 versus $550 in Nevada. The renewal fees are $450 versus $650 in Nevada when you add everything, because Nevada keeps changing and adding. Last change Nevada did was in 2012, and that's what triggered me to look into what else is happening out there, and it was the best thing that happened to me, because that's when I started getting with attorneys and judges, and we cracked the code on the asset protection through Wyoming, through the structure, if it's done on time, with the proper paperwork, which we have. So why pay double set up in Nevada, have to maintain paperwork and complicate your life, when Wyoming is giving us everything we need? So I want to talk about additional key points. Actually, have we answered all the questions?
We have about 4 more questions, if you want to answer them now.
Let's take them. Is that okay with you, John? Is your time okay with you?
Yes, I'm fine.
Thank you, sir.
All right.
You're a good man. Thank you.
Jim's follow-up question to why Wyoming over Nevada is, will I have to file taxes in Wyoming?
Well, this is it. this structure is a tax-neutral structure, meaning you're making a payment from yourself. Let's say the property's in your name. You're making a payment to your Wyoming LLC, so it's tax-deductible from your payment, but it's income to the Wyoming LLC. But since it's a flow-through entity, it's practically tax-neutral. So you just bring the paperwork to the CPA, and the CPA will tell you that even your CPA in your own state, no matter what it is, can just do the paperwork for it. It's very simple. And I don't want to go into details because some people use it for more stuff. I mean, I have people that set up their trading account under that Wyoming LLC. So, yeah, for these people, they'll have to file taxes. Some other people, it will be a disregarded entity. So,
very good. Next follow-up question was for the person that was asking about flipping the single-family homes and how fast you could put the structure together. He wanted me to specify that he was actually asking, will he get the lien in time? So once they place the lien, does it happen that fast? Or
the lien takes effect as soon as it's the day and time it is recorded at the courthouse. I mean, that puts it in line.
Yeah, exactly. It's a very good point. I mean, to John's point, we will send you everything by email. Nothing by mail. It's all by email. You will print it. You will take it. You take that lien. You will sign it, notarize it, take it to the county and record it. If you don't even want to mail it in, just take it and record it. That minute that you record it, you got the lien on. Very good point.
All right. Next question is also kind of a comment. Ty is asking, if I set up this simple structure, lose a lawsuit, you're telling me that I am protected from losing my assets.
Even if he loses, he's not going to lose because the money is owed to the Wyoming LLC. Worst case scenario, he's forced to sell the entity. By law, the creditor's got to be paid first. So there is a first lien, let's say, to Bank of America. You got to pay. Second lien to the Wyoming LLC. It's got to be paid. So there's nothing left. The person ends up with a tax bill, provided, as John said earlier, provided this structure was set up before any lawsuit was initiated against that party.
Very good. John, do you want to add anything?
No, I mean, I agree with that. I mean, that's exactly why you're doing it. And again, like I said before, is that a guarantee that every single thing that could ever be, happen is, I mean, because there's always exceptions to the rule, and that can happen. Now, does that mean that it's going to work 100 times out of 100? Right now, I would say yes. But in 30 more years, there may be some case law that changes some of that. I mean, the law, unfortunately, is an ever-moving thing.
Yes, very good point.
Listening to our Supreme Court every year, you should, it's pretty evident.
Yeah, and you know what? If 20, 30 years from now they change the law or something, and I'm still alive, believe me, we'll look hard to see what other states and what other structure will work on. So.
All right. Our last question here right now is, what if I set the structure up and then file the liens, but then I want to borrow against the property down the road? Is that possible?
Yes, it is possible, because when you go to borrow, you tell the bank that the second lien that's actually recorded there is owed to you because you have the certificate of ownership for the LLC, and you just show the certificate of ownership. So that's all you show. You are in control. That's the beauty about this structure. Great. John, thank you for answering all these. Go ahead.
Well, what I was going to say is what happens is when you show the ownership, the lien that they're going to put on it will now be, your lien will be subordinate to that. In other words, you'll have the first lien, the new bank loan will be the second lien, and then yours will be the third lien. You just basically give up your spot as the second lien.
So remember that the lien is to you. I'm sorry. Go ahead, John. Sorry to interrupt.
Well, no. I was just trying to make sure that made sense, because when when you go to the bank and you want to borrow against that home, and they come in and say, okay, well, fine, but we want to be the second lien because you've already got the first lien on the home. Now you've got a second lien on it that's going to be put on by when you, I guess, as I call it, get the actual equity out of the home. Then you're going to have the LLC lien come in behind that second bank loan. Does that make sense, Sheree?
Exactly. Yes. So first lien is to the bank. Second lien is to your LLC. If you want to go and borrow a second lien with another bank or the same bank, you're just going to tell them, I will subordinate that second lien to the LLC because I own the LLC. This is a loan to my entity. We're going to move it to the third position. They see the certificate of ownership. The title company does it.
Exactly.
Very good.
I didn't say
awesome,
it.
I know you said it right. So if somebody has cash in the bank, I think we had that question by email and I didn't answer it. If somebody has cash in the bank, when we set up the Wyoming LLC, you can actually set up the bank account for it because you get a tax ID, you set up the bank account. You can transfer the cash and put it right under the Wyoming LLC. You're still in control. You're the manager of the Wyoming LLC. You have the checkbook. But like John said, it has a charging order protection, so it can protect your cash, and it does not get dispersed out in a lawsuit or anything. So it is just a way to protect your cash, a CD, a trading account, etc. We will explain all that to you and make it happen for you. So let me go quickly through some additional key points and wrap up the call. Wyoming LLC has it's fully protected against charging orders, and the Wyoming Act is 1729-503 for the charging order protection. This is what gives it that extra edge. The Wyoming LLC must have the properly worded operating agreement. This is what we do. This is what John was just saying right now. It gives you that legal and business reasons to exist beyond the asset protection only. The promissory notes have interest-only payments with a minimum of one payment per year. You're making it to yourself, so it's not a burden of every monthly payment. And how will you remember that you have to make that payment? When you renew the Wyoming LLC, I'll send you an email. I say you need to renew it. That's when you actually pay for the renewal fee. That's all the expense you have ongoing. And then once it renews, now that's your reminder. Just make one payment from yourself to your Wyoming LLC to keep it current, to keep it active. So in case of a lawsuit, it shows that it's form and substance. Any payments you don't make, which is the 11 other payments, are accrued to the principal amount owed. And this keeps making the loan that you owe to the Wyoming LLC bigger every year, wiping out any future increase in value as you pay off the first lien to the real bank and as your property value increases just due to inflation even. Number 4, you do not need to pay any ongoing legal fees. There is no attorneys that you have to call. There is nothing that you need to do. You are in total control of the structure. We're available to answer questions. We do it by email. We do it by phone calls. And you can, at any time, subordinate that loan, write it off, cancel it. You are the actual borrower, but you also are the owner of the Wyoming LLC, and you're full control with the certificate of ownership. You can talk to any title company, and they will help you. Your Wyoming LLC offers you full privacy as an owner and as a manager. Any plaintiff's attorney has to get a court order subpoena to contact the registered agent to get your name and address. It's an extra added advantage. I don't, as I told you, you can tell anybody, I have it set up, provided you set it up on time. Any plaintiff attorney that is getting a lawsuit against you will be completely discouraged, and John made that point earlier. They have a window of time, he said, to agree or disagree if they're going to take the case, and if they see there isn't much equity, they're going to say, you know what, settle with this person's insurance. Let's not go after them because there's nothing. And they're not going to take it on contingency because there's no equity to go after. So they're going to ask for a hefty upfront fee, retainer, and a good hourly fee, and I don't blame them. Nobody works for free. The plaintiff's attorney, that person trying to sue you, will most likely be discouraged because pursuing anything when there is nothing to get is a waste of time for everybody, so they'll settle with the insurance. And litigants who end up still pursuing you in a lawsuit and win, guess what they get? They get an actual IRS bill, which is ruling 77-137 for phantom income. You can look it up on an Internal Revenue Code, irs.gov, and you can see it. It's kind of fascinating to me how this structure works. It's just been, I have $50 million of personal assets in Puerto Rico. The properties are in my name. I'm not afraid to say why, because I'm structured correctly. I haven't been sued when I was structuring it. Thank God I do business the right way, but God only knows where a lawsuit can come from. And as somebody that does trainings and events, etc., and I have my hedge fund, we do the same thing for hedge fund. We have 50 million in assets in the fund. That's how we do it. We properly structure the assets to have liens so nobody would want to go after them. And they immediately try to settle with us or talk to us instead of just fighting us. And by the way, you can pass on the structure to your heirs and continue such protection for years to come, keeping it all under your control and your family's control. By the way, regarding Wyoming, it was rated #1. This is in October 9, 2013 for the 2014 State Business Tax Climate. They love it for business. Wyoming are very pro-business. They have their tax structures the right way. They have everything the right way. I'm very impressed with the way they conduct business. Unlike Nevada and California, they're not in the red. They have a surplus. I mean, this state knows what they're doing. Okay, how to get started? I'm not going to bore you with details here. What we do, I just want you to know it's $5,000, including one entity. I'm going to include one entity. I'm going to include the Wyoming filing fees for those enrolling tonight. And renewal is $450 a year. We do not renew automatically. I always send an email from the office. Would you like to renew? You say yes. You give me a new credit card because we don't keep them on file. Then we just renew for you. And of course, you will renew $450 a year to strip equity on as many properties every year. You can have $1 million property, or you can have 10 properties. It's the same one LLC that you will maintain. It doesn't get any better. People ask me, the biggest question I got the last couple of weeks, since the Wyoming LLC would have all the promissory notes and liens owed to it, practically my entire net worth and all my equity, what would happen when I die? How can I make sure the LLC will not go through probate and will just be passed on to my loved ones without delays or hassles? Very simple, guys. If you already have a living trust, we'll put the ownership of the Wyoming LLC into the trust. That means a certificate of ownership. It's like a pink slip of a car. Okay? It says this LLC is owned by. It could be your name and your spouse's name, or it could be the living trust. If you do not have a living trust, we have created a simple 8-page trust document that will work for you regarding the Wyoming LLC. So I'm going to set up the living trust for you with the legal office we have. All I need you to do when you call the office, write the number down, 407-608-5448. You call tonight, right now. All I want from you, when you talk to Zach, when you talk to Ashley, you say, I want to name the trust, whatever name. Don't use your last name. Just be clever a little bit. Use something that people can track it back to you, for the love of God. I can't believe people tell me I want privacy, then they give me their last name. Okay? Use a name. I don't know, ABC Trust, XYZ Trust, whatever you want to call the trust. Number 2, you're the trustor. Put your name and your spouse's name. If put your husband's name. Put your husband and wife is usually what we get as the trustor. You're the grantor. You're granting. The beneficiaries. Give us your full names of your kids if they're going to be the beneficiaries. Name of trustees. Very simple. Usually it's the husband and wife. Then after the second spouse passes away, what we do, based on what everybody tells us, is usually they want to give it to their kids. So I need the full name of the kids. It's the same name probably right here. So very simple. Just 4 things. Name of trust, your name, the kid's name, your name, and then the kid's name again to make sure you're in full control. You're the trustee, you're in full control. We'll have our legal team fill out what you need. We'll have it set up for you for the Wyoming. You see, fill out the living trust documents. It's 8 pages. We'll just put this for you. We'll send it along by email with your Wyoming LLC structure, including the operating agreement, the promissory notes, the liens, everything. Attorneys' fees charge somewhere around $2,500 to do the living, to do that living trust. Okay, I'm going to do it for you. Those that call in tonight, I'm going to include it for free. No additional charge. Those that are enrolling tonight. Once you receive the living trust document, I want you to print it. You go and notarize it. Then you keep it somewhere safe. Okay, again, you're going to get it. Part of your packet included free this time tonight. And what I want you to do, you print it, Go notarize it, keep it somewhere safe. Very simple. Now, how did I started as a hotel manager many, many years ago in the early 80s, became master of cracking tax codes and asset protection? Well, you see that property I'm standing in front of? This is a chateau in France. It's a castle owned by Edmond Bessari, a gentleman I met in the early 80s. Edmond Bessari is a billionaire, met me in a hotel lobby, the Century Plaza Hotel in Los Angeles in 1981. And he said, Sharif, why are you working so hard? I see you running around in the hotel day and night. I said, sir, I want to become a general manager. I'm 21. He said, come and work for me. I went and worked for Edmond Bessari. He had properties and real estate around the world. Harvard Business School called him the man with two brains. A billionaire in the 80s. The man used to drive Rolls Royces around the world. Here's the photo of Edmond Bessari with President Ronald Reagan. He had donated a lot of money for his library in California. So this is how it happened for me. I mean, it just, I was at the right place at the right time. I was with the right people, and I learned, and I'm trying to pass on the knowledge and how to protect the wealth that you have. Now, guys, if you have multiple liens, each additional lien $695, we will work with you. What, you have 20 liens you want to work? I'll work it out with you. We're going to make it happen for you so we can protect you. We can make it simple for you. And anybody can do this. You don't have to be an expert in law or anything. We do the paperwork. We send it to you. So call me tonight, 407-608-5448. We're going to fill out the paperwork, get you set up, get you going. The simple 8-page living trust will be a bonus tonight. Anybody want to do this, call us 407-608-5448. And John Lawson, I cannot thank you enough. You are a generous man for your time and your knowledge. And I hope maybe you join us on another call in the future. Is that okay, John?
You bet. I appreciate it.
Thank you, sir. All right, everyone. Have a great night. Call the office right now. Please call 407-608-5448 so you can get the bonus, the living trust included. Thank you, and good night.